Welcome to this presentation on unpaid internships in Florida. Still legal in 2026? The short answer is yes, but with strict conditions. As stated on the official website of the U.S. Department of Labor at dol.gov, the Fair Labor Standards Act requires most workers to be paid minimum wage, unless a specific exemption applies. Florida courts follow the 11th Circuit's primary beneficiary test from the case of Schumann versus Collier Anesthesia, decided in 2015. In Florida's minimum wage in 2026 is $13 per hour, almost double the federal rate of $7.25. This means the cost of misclassifying an intern is much higher in the Sunshine State. Throughout this presentation, we will break down the 7 factors of the primary beneficiary test, explain Florida-specific risks, and give you practical guidance. You can find the full text of the Fair Labor Standards Act by scanning the QR code on this slide, which links directly to the Department of Labor's fact sheet number 71. Before we dive into the internship test, we need to understand the baseline. According to the Fair Labor Standards Act of 1938, specifically Section 6 found at Title 29 of the United States Code, Section 206, for-profit employers must pay at least the federal minimum wage, which is $7.25 per hour, a rate that has not changed since 2009. Section 7 of the FLSA at Title 29, Section 207 requires overtime pay at 1.5 times the regular rate for any hours worked beyond 40 in a single work week. The FLSA defines the term employ very broadly, as to suffer or permit to work. This definition found in Title 29, Section 203, letter G, is intentionally broad and catches many misclassified workers, including interns. Here's what the official rules state. In Florida, the state minimum wage in 2026 is $13 per hour, as mandated by Article 10, Section 24 of the Florida Constitution. Employers must pay whichever rate is higher, federal or state. So for Florida employers, that is $13 per hour. For the official text of the FLSA, scan the QR code on this slide to visit the Department of Labor's FLSA overview page. So what is the test that courts use to decide if an unpaid internship is legal? In Florida, the controlling precedent comes from the 11th Circuit Court of Appeals in the case of Schumann versus Collier Anesthesia, decided in 2015 and published at 803 F3D 1199. This decision adopted what is called the primary beneficiary test. The test is a flexible, holistic balancing test with 7 factors. No single factor is determinative. Courts weigh all 7 together to assess the economic reality of the relationship. The core question is simple. Who is the primary beneficiary of the internship? The intern who gains education and experience, or the employer who gets free labor? As explained in the Department of Labor's fact sheet number 71, available at dol.gov, the 7 factors cover compensation expectations, the educational nature of the training, academic credit integration, schedule accommodations, the duration of the program, whether the intern displaces paid staff, and whether there is any entitlement to a job afterward. Scan the QR code on this slide to visit the 11th Circuit Court of Appeals website for more on the Schumann decision. Now let us examine each factor in detail, starting with Factor 1. Under the first factor, both the intern and the employer must clearly understand that there is no expectation of compensation. According to the Department of Labor, this means no promise of payment, whether express or implied. Even a future promise of a paid job can be construed as compensation under the FLSA. The strongest evidence for this factor is a signed written agreement, executed before the internship begins, that explicitly states the position is unpaid and that there is no commitment to future employment. If the employer later provides any payment, even a small stipend, the analysis shifts dramatically toward employee classification, and the intern would be entitled to at least the minimum wage. As the U.S. Supreme Court held in the 1947 case of Walling versus Portland Terminal Company, the original test for trainees focused on whether the employer received immediate advantage from the worker's activities. Scan the QR code to visit the DOL Wage and Hour Division page for more on internship compliance. Factor 2 asks whether the internship provides training that is similar to what the intern would receive in an educational environment. This means the program should include structured mentoring, hands-on instruction, rotation through different departments, and regular feedback and evaluation. The key question from the Schumann case is this: is the intern learning new and transferable skills, or simply performing repetitive tasks that benefit the company? In the Schumann case itself, The 11th Circuit ruled in favor of the employer because nurse anesthetist interns received intensive clinical training in a structured program with faculty supervision. The training was genuinely educational in nature. But if the intern spends all day filing documents or answering phones with no instruction, that looks like employment, not education. For more detail, scan the QR code on this slide, which links to the Code of Federal Regulations, Title 29, Part 570, covering child labor and related FLSA provisions. Factor 3 considers whether the internship is tied to the intern's formal education program through integrated coursework or the receipt of academic credit. When a college or university awards academic credit for the internship, it strongly suggests that the intern is the primary beneficiary of the relationship. Many Florida universities now require internship courses with defined learning objectives, reflective journals, and faculty evaluations to qualify for credit. The Glatt versus Fox Searchlight Pictures case from the Second Circuit in 2016, which is cited at 811 F3D 528, is a key reference here. In that case, interns who were promised academic credit but received no formal instruction were found to be employees. An internship with no academic component at all, no credit, and no coursework connection leans strongly toward employee classification. Scan the QR code on this slide to visit the U.S. Supreme Court website for more on internship-related case law. Factor 4 examines whether the internship accommodates the intern's academic commitments by corresponding to the academic calendar. A well-designed internship should not require the intern to skip classes, miss exams, or fall behind on coursework just to participate. Flexible scheduling around semester breaks, exam periods, and project deadlines shows that the program is designed for the intern's benefit, not the employer's convenience. The Department of Labor's guidance states that the duration of the internship should correspond to academic terms or defined learning periods, not the employer's ongoing staffing needs. This factor, alongside the others, was applied in the case of Benjamin versus B&H Education, where the court analyzed whether the internship schedule truly served the student's academic needs. Scan the QR code to visit the DOL Youth Rules website for more guidance on student employment. Factor 5 focuses on the duration of the internship, which should be limited to the period during which the intern receives beneficial learning. Once the intern has acquired the intended skills and knowledge, the program should end. Continuing beyond this point suggests the employer needs ongoing labor, not that the intern is still learning. Courts view open-ended or indefinite internships with deep suspicion. They often indicate employment, not education. A defined end date tied to a semester, a specific project, or measurable learning outcomes strongly supports unpaid internship classification. This factor traces its roots back to the landmark 1947 Supreme Court case of Walling versus Portland Terminal Company, which established that trainees could be exempt from the FLSA only when the employer derived no immediate